And now we move on into Unit 10. That's right, there's been a change in scenery and a change in wardrobe, because it's now Christmas break. And so we are now, while you all are at home after exams, relaxing and watching television, putting your feet up, and no doubt enjoying time with loved ones, and playing FIFA, and enjoying Star Wars. I'm at home recording lectures for you. Not that I'm bitter. At all. Just a little bit. So, this next unit, Unit 10, is dealing with the American legal system. It's time for fun with lawsuits and Supreme Courts and judges and so forth. So, hopefully by this point you've received your outlines. If not, well, have fun. No, you've got outlines coming here somewhere. If not, pause it until someone can figure out where they are, but, you might want them. So, here we go. Unit 10, Lesson 1, the basics of law in the American legal system. Starting first of all with Roman numeral 1, letter A, the functions of law. Why exactly do we have laws? What purpose do laws serve? Things like that. The law serves 5 basic functions in American society. The first one being security. The idea of this one is sort of the obvious one. Laws keep us safe from each other. Whereas most laws, most laws don't serve to stop us from ourselves, although some do. Most laws are designed to keep us from each other by establishing a code of ethics that we are all cool with. So the idea of security is that the law protects us from each other. It's the law, laws that say things like, you can't kill each other, you can't steal from each other, this is okay to drive over this limit, you can't drive faster than this, etc. It provides security in order to keep us safe, happy, and alive. The second one, predictability. The idea of predictability is that the law creates repeatable scenarios so that we always know what we can and can't do. Again, the idea is that the law creates repeatable scenarios so that we always know what we can and can't do. Third time. The law creates repeatable scenarios so that we always know what we can and can't do. The idea of predictability is that it eliminates the guesswork before we can perform an action. If we wonder, you might be wondering what this is. This is, a balloon of Winnie the Pooh, just in case you were wondering, because I know I was wondering what that golden thing was that was rotating behind me. It's Ellie's. Thank you very much. Now then, predictability, as I was trying to say, is that predictability is the idea that we are allowed to do, that way we can know what we can and can't do. For example, in the middle of class, Kai just accidentally says the F word, and I just go, that's hilarious, Kai. That's just great. I love that. This guy's a comedian. And then 5 minutes later, Luis happens to say the exact same swear word, and I go, you know what, Luis? You are expelled. The problem is that because of the unpredictable nature of that scenario, nobody knows what's acceptable and what isn't. So you don't know if saying a bad word would get you in trouble or not. And that creates chaos. The law exists to create a set of rules, very visible, black and white, this is okay and this isn't okay, so that we can adjust our behavior accordingly. So that's what predictability is getting into, the idea that it allows us to adjust our behavior because we always know what is and is not acceptable. The third one, conflict resolution. The law provides a way for us to solve our problems between each other without having to resort to violence. Again, conflict resolution is the idea that the law allows for a means for us to settle disputes between ourselves without having to resort to violence or any other sort of problems. Again, conflict resolution is the idea that the law allows for us to resolve our conflicts or fights meaningfully without any sort of, having to deal with violence, etc. So this is getting out of criminal law and into more like civil law. So for example, my neighbor keeps dumping their trash on my lawn. I can sue them. I don't have to go get a shotgun and blow them away. I think that, Toyota made a terrible car and that's why my family is dead. I can sue them. I don't have to hunt down the CEO with a bow and arrow. Things like that. So again, it allows us for an adequate conflict resolution. Even if you think about criminal law kind of works the same way. Society says, we don't like what you're doing, so we take you and we put you in jail. So the idea is it allows us to solve issues between each other without having to resort to taking the law into our own hands, if you've ever heard that phrase. That's what that's talking about. The idea of taking the law into our own hands is settling our disputes ourselves. The law means we don't have to do that. It helps us to provide a peaceful resolution for our conflicts. The fourth one, social conformity. Social conformity is the idea that the law reinforces what we find acceptable as a society. It pressures people to find things or to follow things that are acceptable. It again pressures people into following behaviors or doing behaviors that we as a society have deemed acceptable or stopping them from doing things that are unacceptable. Again, it's the idea that law pressures people into doing things that we find acceptable or stops them from doing things that are unacceptable. This is where you get into what are called quote-unquote victimless crimes. Like, we have laws against things like gambling, alcohol use, drug use, public nudity, I guess, would fall here. These are not because they are going to do damage to society, to us, or to other people necessarily. I mean, like, if I put $20 on the Panthers game, who is it really hurting? And you get down to it, besides, you know, my banker. But the point is that we as a society have said, this is not something we're okay with, so we put laws in place to stop it. Likewise, you know, again, same things like drug use and stuff like that. We are not okay with people using drugs because it would hurt themselves and potentially could hurt others, so we have laws in place to stop that. Think about like the dress code at school. The dress code is, at least in theory, created as a method to enforce certain behaviors and discourage behaviors that the society has deemed to be distasteful and so forth. So that's why dress codes exist. Not because, you know, we're afraid that, you know, your bra strap is actually going to cause mass panic, but because we as a society have determined that this is acceptable and this is unacceptable. So by using the law, we are going to hopefully enforce conformity. So again, whereas the other laws are more about, or the other uses of law like security, predictability, and so forth, all that's talking about are dealing with other people. Social conformity is oftentimes trying to save us from ourselves, if you will, trying to enforce behaviors that affect us personally, but are still significant because it can influence society and influence others. And finally, distribution. We use the law to distribute resources, to determine who gets what. And finally, again, distribution. We use the law to determine who gets what resources to distribute. Again, third time, we use the law to distribute resources to determine who gets what. And I'm now realizing, I think with each of those definitions, I said it's slightly different each time, but I think if you rewind and watch all three of them and sort of average them out, you'll figure out exactly the correct definition. What I'm getting at is, we use the law to say, again, who gets what resources. So think about like the laws that govern things like Medicare and Medicaid. We say that once you reach a certain age, you are entitled to this program. Or if your income is below a certain bracket, you are entitled to this. But it's more than just resources like money. It also includes resources like freedom and so forth. You've broken this rule, therefore you are no longer entitled to this resource we call freedom, or the ability to own a gun, or the ability to vote, or the ability to drive a car, or whatever. All of those abilities are considered to be resources. Civil rights in general can be considered a resource. So we have laws in place that determine who can and cannot use these resources. So those are the 5 basic functions of law. As for how the American legal system works, you sort of have a combination of 4 elements. There's the civil law tradition, the common law tradition or structure, the adversarial system, and the litigious system. The idea of civil law structure is that this is the basis that a lot of countries use for their legal system. The civil law structure, created in France, is the idea of a comprehensive code of laws created by a legislature. In the civil law structure, it's a comprehensive code of laws created by a legislature. A comprehensive code of laws that's created by a legislature. Again, created by France. In the common law, or the civil law tradition, I should say, sorry, the civil law structure, again, created by the French, found a lot in French former colonies like the Philippines and so forth, and Louisiana, weirdly enough, but we'll talk about that. In this system, the law is very, very detailed and very, very complex, and it's created by the legislature. The job of the referee and of the courts, rather, is basically just to be an inquisitor, to actually determine whether or not you've broken the law and so forth. So they actually can do interrogations and so forth. Quick gamers, if anyone's played Phoenix Wright, that would be the civil law structure. And if you've played those games, you kind of know how bad a lying witness can be for that reason. I'm sorry, back on topic. It was created by Napoleon as part of the Napoleonic Code. In the civil law structure, again, it's more about, again, a very, 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 very detailed set of laws. There is no gray area. We use parts of the civil law tradition. Louisiana uses it mostly because, again, Louisiana was French territory, and Louisiana just likes to be different. Most of the U.S., however, uses the common law structure. The common law structure, or the common law tradition, whichever phrase you want to use, created by the English, it instead is based upon an accumulated series of court rulings. Under the common law structure, The law is based around an accumulated set of rulings. These previous rulings are called precedents. Precedents are the previously established cases. Precedents are previously established cases. Precedents are previously established cases, and these precedents tell us how we should act. This is why whenever we talk about Supreme Court cases, each of those cases is a precedent or creates a precedent. So because of what the court ruled in, say, Tinker v. Des Moines, that governs our actions from here on in. It tells what schools can do and can't do, or it tells the government what they can and can't do, or it tells individuals what they can and can't do. This is the basis for U.S. law, because again, it was created in England, we were an English colony, it makes sense, we stole their system of government. Precedent is supposed to be, again, sort of the key thing for the court. The catch is, with precedent, is it's a bit like with amendments. The most recent one is the most significant one. So this is why you can have decisions that overturn precedent. For example, Plessy versus Ferguson, remember, was the Supreme Court case that said that you could segregate, and then you had Brown versus Board of Education that said you couldn't, or Furman v. Georgia and Gregg v. Georgia. So we do occasionally overturn precedent. The other thing is we don't have a strict common law structure. We mixed it with civil law, because remember that we do, of course, have a legislature that makes laws. The difference being, though, remember that the laws that our Congress makes and that our state governments make tend to be somewhat vague. They also tend to be somewhat of a hodgepodge. They tend to sort of, mix together and create sort of weird dead ends. That's why the courts are used, because that way when we have laws that don't match, the court steps in and says, this is acceptable, this is unacceptable, this jives with the Constitution, this doesn't. So the common law structure is probably the biggest part of our court system, but we do use elements of the civil law as well. Now then, you've also got the fact that we are an adversarial system. An adversarial system is one in which two opposing sides argue their case before a neutral judge. The definition of an adversarial system is one in which two opposing sides go at each other with a neutral judge. It's, again, a system in which two opposing sides argue and go at each other with a neutral judge standing in as sort of, again, a neutral arbiter, as a central referee. The logic behind the adversarial system is that you have two sides, one that says A and one that says B. As they argue, whoever has the most evidence will be found correct, and therefore is the most likely to be true. So the logic is that somewhere in that fight, the truth will come out. Because logically, the side that's right will have more evidence, because otherwise they wouldn't be right. The judge's role, therefore, is not to determine whether you're right or wrong, but rather just to be the referee, to keep the sides fair, to make sure that the rules are safe for both sides. This is part of the reason why, in the United States, we do not find you innocent in a criminal trial. We find you guilty or not guilty. Because if you're found not guilty, we're not saying you didn't do it. We're just saying there's not enough evidence to prove your guilt. The judge, this is also why I like saying, a judge might let a murderer go free even if there's a lot of evidence. Because if they've broken the rules, remember the exclusionary rule, if rules are broken, it's more important that the prisoner go free and the court's integrity be maintained than it is for simply justice to be done. Because again, the idea is that the judge is neutral and cares little about your guilt or innocence, but cares more about how the trials actually functioned. This is also why, in the U.S., judges can't talk to witnesses. Judges cannot investigate. And that's, again, somewhat unusual. In many countries, the judge is actually more like a detective. They can actually conduct inquisitions. They can go gather evidence because they're trying to find the truth of the matter. Under the U.S. adversarial system, the judge doesn't do that. The judge is simply ruling about whether or not the procedures of the court are being done correctly. Again, the logic here is that if you did it and you're guilty, then the evidence will say you're guilty. And therefore, in the arguing between my side and the government's side, them saying I'm guilty and me saying I'm not, because they are right, they will have more evidence, and therefore they will find me guilty. The flaw in this logic, of course, is that the rules of the court system can be somewhat problematic. And so as a result, even if we, quote-unquote, know something to be true, it can still get tossed out. It can still create a problem. Now then, litigious system, the fourth one, litigious system. The idea of a litigious system is one in which we can use the law against each other. In a litigious system, meaning that we can use the law against each other. We can sue. I mean, that's the easiest way to put it. A litigious system, again, we can use the law against each other. We can sue each other. This is our way of actually, we don't need the government to use the law. We can also use laws against each other. Again, this would be what you call filing a lawsuit, or a civil suit is also what it's known as opposed to a criminal case. A civil case in this case, in the U.S., a civil case means it's a litigious case in which we are suing another individual. The difference between the two, and we'll get into this a little bit further down, is that in a lawsuit, you are seeking money. In a criminal case, you're going to jail. That's the biggest difference. That if I'm suing somebody, I'm not sending them to jail. I'm just trying to get money. But the litigiousness of the system does allow for us to still essentially determine things like guilt or innocence. This is where words like punitive damages comes into play. Punitive damages are or financial decisions in a lawsuit that are created as a result of punishment, a way to punish a company or something like that, or an individual for doing something wrong. So for example, let's say that Nike made a terrible, terrible shoe that the other day I was running and the back of the shoe completely fell out and I fell over and broke my ankle. Now, I might be given, say, $500,000 for my pain and suffering and medical bills, but the court might also give me, say, $100 million in punitive damage. The $100 million being a punishment to Nike saying, you know you messed up, this is your penalty. So punitive damages allow for us to use the litigious system as a way of seeking out punishment and so forth. So you might, again, like say, your neighbor refuses to stop their dog from pooping on your lawn. You can't collect $3 million from damage because, that would be a lot of poop. Instead, they might assign $3 million in punitive damages as their way of punishing your neighbor because they knew they were doing something wrong and did it anyway. The flaw in this, of course, is the fact that anyone can use the system this way. Anyone can file lawsuits and so forth. This is where you get into the idea of frivolous lawsuits. Frivolous lawsuits is a negative term. It's a term applied to someone filing a lawsuit without cause. It's a term applied to somebody filing a lawsuit without cause. Again, it's a term for somebody who's filing a lawsuit without cause, meaning that they don't legally have a leg to stand on. They're just hoping to file a lawsuit in the hopes of getting money or getting attention or whatever. In many cases, in fact, these frivolous lawsuits are filed purely for nuisance value. What nuisance value is, and again, this is a term you could write down as like an extra term, wouldn't be a bad idea. The idea of nuisance value is companies, when they are sued, they have the option of going to court or they have the option of settling out of court or paying you a lesser fee. So for example, if I'm suing Nike for $10 million, they might offer me $1 million to go away. That's what you would call a nuisance value settlement. In other words, it's worth the fact that they're only paying 10% of what I wanted just to get rid of me. Or, like I go to McDonald's and I slip on a wet floor and I sue them for $500 million. They might throw me $500,000 and say, go away. And so oftentimes people will file frivolous lawsuits in the hopes of getting a nuisance value settlement. This, of course, is not what the system's designed for. It slows down the system, it cheapens actual problems, and so forth. And so in many states, you have a movement towards what's called tort reform. Tort reform is an effort to fix the litigiousness of the system and make it more difficult to file frivolous lawsuits. Tort reforms are reforms that are designed to fix the litigiousness of the system and make it more difficult to file frivolous lawsuits. Tort reform, again, is an effort to fix the litigiousness of the system and make it more difficult to file frivolous lawsuits. For example, in many states, they have what's called loser pays, meaning that if you lose the case, you have to pay the legal fees for the winning side. Which, of course, if I lose a case against Nike, I'd have to pay several $1 million in lawyers' fees because they have a lot more lawyers than I do. Other states can actually, stop you from suing by declaring you a malicious litigant, saying you are no longer allowed to file lawsuits because you broke the law, because you've used the law too many times. Tort reform has a lot of supporters because the idea is, again, it helps to speed the system up. It gets rid of all these frivolous lawsuits. But the problem with tort reform is it also cuts down on legitimate lawsuits as well. Because, I could always get bullied by a big corporation with hundreds of millions of dollars and more lawyers than I could ever hope to have. Go watch Aaron Brockovich or any of those other movies where a valiant underdog takes on a huge corporation. So the problem with tort reform is that, again, it's a broadsword. It can knock out frivolous lawsuits, but it could also knock out legitimate lawsuits as well. Now, we move on into letter C, which is kinds of law. Excuse me, I'm going for 20 minutes now. Now then, kinds of law. You've got, how many did I give you? 5, 6, 7, 8, 8 different kinds of law. Starting with procedural law. Procedural law is laws that govern the procedures. I know that's kind of like answering a question with a question, but you know what I mean. Procedural law, again, is laws that govern procedures. It tells you how things are supposed to happen. Procedural laws are laws that govern procedure. They tell you how things are supposed to happen. Procedural laws are laws that govern procedure. They tell you how things are supposed to happen. In other words, these are the laws that, for example, tell a bureaucracy how to function. These are laws that tell you how you can acquire a license. These are laws that tell you what the correct like how test moratorium day works. If it's telling you how something is accomplished, it's probably a procedural law. Procedural laws, by their very nature, usually do not have judgments in place or values in place. It's simply, this is how you proceed. If you fail to proceed in this way, punishments can occur. But for the most part, they are not telling you, again, what you can and can't do. They're telling you how to do something. What you can and can't do is substantive law. Substantive law deals with what you can and can't do. This is where you're getting into values and so forth. So substantive law is dealing with what you can and can't do. Again, this is where values come in. So substantive law would be things along the lines of you can't rob, you can't murder, you can't steal, you can't wear white after Labor Day. Those are substantive laws. Substantive laws are the ones that are usually passed by the legislature, whereas procedural laws are usually passed by smaller groups like the bureaucracy or judges for that matter. Substantive laws are sort of the bulk of what we think of when we think of the legal system, whereas substantive law, or rather procedural laws, are more found, again, in more common places like the bureaucracy, school, etc., etc. The third one, criminal law. Again, criminal law deals with breaking the laws of society, actual punishable laws and things like that. Criminal law, again, if you break criminal law, you're going to go to jail, whereas if you break civil law, you're just going to get sued. So, again, criminal law is created by the government. Other things about criminal law you should know. Again, governs behavior that with the government is determined to be harmful. Violation of criminal law is called a crime. Violation of criminal law usually involves jail time or a fine. Civil law, on the other hand. Civil law is laws that govern the interactions between individuals. Civil law is law that governs the interactions between individuals. Civil law is a law that governs interactions between people, individuals, whatever. Civil law, also created by the government, but the difference again is that whereas criminal law is between you and the government, civil law is between you and another person. So even though the government might make a law, in a civil law case, it's you and another person. Again, you're suing the company, you're suing your neighbor, you're suing somebody. Criminal law, it's always the government versus you. There is no third party. It's the government versus you. Violation of civil law is called a tort. Hence why when we were trying to fix the litigiousness a few minutes ago, it was called tort reform. Now, here's where it gets entertainingly tricky because one action can be a violation of both criminal law and civil law. For example, if I were to go out and murder somebody, that is a crime. However, it could also result in a lawsuit because I could be sued for wrongful death. The difference between the two, again, is criminal law, you go to jail. Civil law, you owe money. So, and we'll talk about, there's another big difference, which is the burden of proof, but we'll get there. We're getting ahead of ourselves. Again, the difference here is that in criminal law, you go to jail. In civil law, you owe money. So, again, like if I murder somebody, the government's going to try and put me in jail, but my victim's family could also sue me to try to get money out of, their loss. Okay, the next one, constitutional law. Constitutional law is, law that deals with the Constitution. Fairly self-explanatory. It's laws that are stated in the Constitution or in judicial decisions about the Constitution. It's either law that's stated in the Constitution or in judicial decisions about the Constitution. It's laws that are either stated in the Constitution or in judicial decisions about the Constitution. So, for example, Brown v. Board of Education says segregation is illegal or unconstitutional. That's an example of constitutional law. Now, other laws like the Civil Rights Act of 1964 were later passed. That decision carries the weight of a law. Likewise, Obergefell v. Hodges that we talked about, the one that created gay marriage, that is essentially constitutional law. They created a law by rendering a Supreme Court decision. That's just how that works. So, constitutional law, again, is law that's either in the Constitution itself, which, again, is not common, but more oftenly it's referring to decisions made about the Constitution, Supreme Court cases, and so forth. Statutory laws, on the other hand, statutory laws are laws that are created by a legislature, by statute, hence the name. Statutory laws are ones that are created by a legislature. They're called a statute, which would, again, be why it's called statutory law. Statutory law loses to constitutional law. Judges can declare statutory law unconstitutional. They can overrule statutory law and so forth. Constitutional law is a little bit harder to overrule because, again, it requires another precedent or a really compelling reason. So statutory law generally weaker than constitutional law. Administrative law. Administrative law is law that is carried out only by the federal bureaucracy. Administrative law is law that is only carried out by the federal bureaucracy. This is laws that are generally created by Congress telling the rest of the bureaucracy how to function. So think of it like procedural law on a grand scale. So administrative law, again, is only done in the federal bureaucracy. It's basically created by Congress to tell the bureaucracy what to do. So again, it's procedural law on a grand scale. So this would be like the laws that say who qualifies for Medicare and Medicaid. That is administrative law. It's then up to the bureaucracy to create procedural laws to how you collect it and so forth. So again, administrative law is like procedural law on a grand scale. And our final type of law, executive order. We've talked about executive order several times now, but for those of you who don't remember, executive orders are created by the president. They're supposed to be an expansion or clarification of existing law. Executive orders are laws created by the president, or orders issued by the president, more accurately. They're designed to be clarifications or expansions of existing law. He's not supposed to use this to create law out of whole cloth, but rather to clarify. For example, again, President Truman used the Declaration of War passed by Congress to desegregate the military. He took a law, the Declaration of War, and he expanded it by saying any army that is at war cannot be segregated. So, executive orders are probably the rarest of all 6 of these, or 8 of these, I guess, but they do still carry the weight of law. Okay, I'm pretty sure that takes care of everything in Roman numeral 1. Whew, that was a lot, so feel free to fast forward, to rewind and go on and so forth. But otherwise, on to Unit 2, or on to Roman numeral 2 in just a few moments.